So your client comes in and says, I was flying in or I was crossing the border, and when I got to the immigration checkpoint or when I passed through immigration at the airport, they took away my visa and they sent me back. What does that mean for their immigration case? Are they going to be able to file a family petition? Are they going to, do they have a deportation on their record? Were they excluded officially from the country? Do they need any waivers in order to get back? I recently took a couple of questions online, and I get this question pretty frequently from clients as well as they come to the office. And that's their question. They say, this thing happened to me. I don't know what the consequences are. They said something about 5 years or 10 years or whatever, and I got to know what I can do. That's our topic for today. What happens when your visa is taken away at the border? I'm attorney James Betzold, and this is the Prima.Law podcast in conjunction with our friends at Visa Feliz. So maybe it's you, maybe it's your family member, maybe if you're an attorney, maybe it's your client. Right? They go to the border, they go to enter on their visa, right? They've been issued a visa, they should be able to get into the country, and there's a problem, right? So maybe the immigration officer sends them to secondary inspection. So let's suppose they're at an airport. This happens a lot at airports. So somebody's flying into the United States, they land in, let's say, Chicago, and when you land your first stop on an international flight, you're going to have to pass through immigration and customs, right? So in the U.S., you're standing in line and you're going through that whole process where you're going to, probably give a fingerprint, hand over your green card. They're going to stamp. Well, they used to stamp your passport. I think it's more electronic now. And when that happens, they'll be asking you a couple questions. Hey, so what's your purpose of your visit? Who are you going to see? Why are you here? What are you doing? How long are you going to be here? And if any of the answers make the immigration officer suspicious, they can send you to what's called secondary inspection. When you're in secondary inspection, this is also known as the little room or el cuartito in Spanish, right? They send you to a little room and they're going to ask you some more questions. They're going to look over your record. They're going to see if there's anything else they can get from you, some information to show whether you should or should not be admitted to the United States. Okay, so if you get sent to the cuartito, if you've been there before, you know what it's like. I have been there due to a very short trip overseas and coming back in short notice. So it can happen to anyone. But if you hold a visa to the United States, so if you're a green card holder, it can happen to you as well. But typically, this is with someone with a tourist visa, right? If you have a tourist visa or some other sort of visa, could be a student visa, and you're entering the United States again, and there's any question about the legitimacy of the purpose of your travel, then they can send you to the cuartito. They will ask you some questions, and they will try and get to the bottom of whatever's going on. Now, probably the most common reason that someone would end up getting denied is because the immigration official says, you know what? I just don't believe you're here for the purpose of your visa. I believe you have the intent to remain here permanently. Okay, now if we're talking about a residency visa, not an issue because you are a permanent resident. You can be here permanently. But someone on a student visa, somebody on a tourist visa, or if they're in transit, they have some other sort of visa that gives them temporary permission for a specific purpose. And instead, the immigrant has shown signs or there is evidence that they're intending to be here permanently. Well, that's the reason they can be refused entry at the border. You see, that visa that they obtained, the temporary tourist visa, isn't a guaranteed entry into the United States. It gets you on the plane and gets you in front of the immigration officer. It's the immigration officer who each time is going to review you. They're going to review the facts surrounding your entry, etc. Maybe what you've taken with you, maybe what's on your phone, and we'll get to what they can all search through. But they need to determine if you're actually here for that purpose, temporary business or pleasure, right? If you have that visa. And if there's anything to indicate that you're like working full-time here, right? Maybe you have a paycheck stub in your phone or a paycheck stub in your purse or your luggage or something like that. If they find that you've been working permanently here without the correct visa to do so, that's a reason that they can say you have immigrant intent and you intend to be here permanently and you do not have the correct visa for that. So that is one of the most common reasons that people get stopped at the border and are denied entry. So in some of these situations, let's talk about the evidence that they find. Like I said, it could be those paycheck stubs we just talked about if somebody has paycheck stubs there. But immigration can go through your phone. They can demand you hand over your phone. And if you want to enter the United States, you have to show them your phone. You have to show them your text messages. You have to open your social media accounts for them, your Facebook Messenger, your WhatsApp, your Facebook posts, your X or Twitter, or whatever other social media is the social media of the day that people are using. And especially from your country, like international travelers from Latin America, frequently it's WhatsApp, right? They're using WhatsApp. So immigration, Border Patrol, right, at the airport, they know to ask for those things. They say, hand over your phone, let me see it. And they'll find stuff there, right? They can check your emails. They can go through all of your stuff. And if they see anything that indicates you're going to be here permanently, they're going to be denying you entry to the United States. So again, they can look through your phone or laptop, text messages, right? We didn't mention that, but that's another obvious one. Old social media posts that contradict the story that you're giving them. But it's usually tipped off. By something the immigrant says, or it could even be because they've entered the United States very frequently or too much to be really just a tourist or here to be on business or pleasure, temporary business, which is allowed in certain circumstances. So if they look at your history of entries, they may see, hey, you've been here like 10 times this year. You stayed like 3 weeks each time. That's 30 weeks out of 52. You're here a lot. What's going on? And that's when they're going to want to dig deeper for sure. Now, that doesn't automatically disqualify you because we have what are called grandparents, abuelos, abuelas, right? And it may be permissible for them to enter and leave frequently on a tourist visa like that. But if the abuela or abuelo is working here in the United States and is doing stuff that violates the terms and conditions of their visa, yeah, then that can be a problem. So those are some of the main reasons that will tip off immigration that there's something going wrong. And there's one more. If something raises their suspicion, they'll say, all right, pull the luggage. Let's take a look at the luggage. What are you bringing? And if this person is bringing lots of clothes, lots of household items, lots of shoes, lots of jackets, everything, like if they're getting ready to be here for a year and they've packed and brought all that stuff, it's going to be obvious in the luggage, and that's going to be suspicious as well, okay? So everything from what's in your digital media, what's in your messages, to what's in your luggage can be a reason that immigration becomes more suspicious and may end up denying your entry to the United States. So that's reason number one, right? Immigrant intent, that the person actually intends to be here permanently or immigrate here without the proper visas or permission. Now, the other reason could be what's called fraud and misrepresentation. Now, this is the most common one because if you're caught by immigration at the border and you're entering with the intent to stay here long term, well, you've already committed fraud and misrepresentation. So not only do you have immigrant intent, the fact that you applied for a tourist visa, you showed yourself to the immigration officer with your tourist visa that you should know doesn't let you stay forever, and you're presenting yourself as if you want to enter on that temporary visa, but your intent is to be permanent, well, that's fraud. That's misrepresenting the true facts. That's trying to deceive the immigration officer so they let you in and you can go forward with your plans. So many times it'll be expressly written on the documentation that this person had immigrant intent and fraud or misrepresentation was the issue. Now, that's not the only reason somebody can be in trouble for fraud or misrepresentation. For example, if you're traveling with a document that is not yours, right? Maybe the person looks like you, maybe it's a family member, maybe you sort of look the same, or maybe it's got your photo, but their name and information because it's a fabricated document. Well, that's more clearly fraud, right? You've either created or possessed or used a fraudulent document to try and get an immigration benefit in the United States, right? And you intended it, right? It's not like you did it on accident. You've got to go through a lot of intentional steps to get to that point. So what can happen is the immigration officer runs the card. They ask you, hey, what's your birthday? Hey, where'd you live? Hey, where are you going now? Why are you going there? Who's your mom? They can ask you those questions to make sure you know who you are. And the fingerprint, that's the big deal, right? It's not going to match. If you're trying to get in on somebody else's visa and they're fingerprinting you, I guarantee you're going to fail that test. Fingerprints are a very good source of individual identification and a very easy way for immigration to catch you in a lie. Now, this can be tricky because sometimes people commit fraud or misrepresentation, and this sort of scenario is more common on maybe the southern or northern border where we actually have entry in cars or trucks, right? Or maybe on foot. They're crossing the bridge in El Paso to come to at Ciudad Juarez to come to El Paso, maybe to just buy some stuff and go back walking. But if somebody's walking or entering by land to the United States and they have a fake document, or maybe they're acting under duress, like they don't have a choice, maybe they've been threatened and they have to go in and try and enter like this. If you show up at the border and you say, help me, I'm under duress, they're forcing me to do this, they told me to give you this card, but this is not me, that can be considered a timely retraction. So, for example, if they give you a U.S. birth certificate or a U.S. passport that's fraudulent, that's not yours, normally if you give that U.S. passport or show that, you're then committing a crime. It's a crime and it's also an immigration offense. So what that means is a false claim of citizenship after October of 1995, I believe it's 95, will disqualify you forever from becoming a U.S. citizen. There's no waiver for it, nothing, right? The exceptions are very rare if you have a family member and if you actually thought you were a citizen. So declaring falsely that you're a U.S. citizen is a big deal. But if you retract it in a timely manner, then they may not use it against you in further immigration proceedings or applications. So, for example, if they show up and you hand them the passport and they say, and before they look at it, or maybe they just glance at it and say, is this you? And you say, no, it's actually not me. Well, that may be considered a timely retraction. That's sort of skating the line because you have to retract your statement before they've relied on it or before they've looked into it further to verify it or not. So if they're just taking a casual glance, is this you? Nope. Okay, well, come tell me what's going on. But if you say, oh, yeah, that's me, and they go, okay, wait right here, I'll be right back. And then they go and then they investigate and they check and they say, I'm going to ask you again, is this you? Because they want you to tell them right away. They don't want to get in a back and forth. Well, then it's too late for a timely retraction. In most circumstances, if it happens like that, and then you say, oh, yeah, it's actually not me, it's my cousin. Okay, well, they've already verified it. They already know. And so it's too late for you to retract it and still be considered honest. Okay, so that's another one that actually happens. We've had a lot of people consult about that. People thinking that they can just let somebody else borrow their green card or their passport or something like that, and then they enter on a false one. Or this could even be if somebody commits fraud in the application to get their visa. So a very common scenario of that is somebody actually enters the United States, lives here for more than a year after 1997, and then they leave and they're like, well, I want to go back. I'm going to get a visa this time. So they apply for a tourist visa. Well, one of the questions on the tourist visa application is, have you ever lived in the United States and from when to when? And if you leave it blank or if you say, no, I never lived in the United States because I don't think they have any proof. Well, if you do that, they're going to find out. And when they do find out, they'll cross-check information. And then when you're entering at the border, they'll say, hey, actually, we have evidence you were here before because of this, this, and this. And then they'll say, we're accusing you of fraud or misrepresentation, so we're going to cancel your visa. Or maybe they'll give you the chance to withdraw the application, but it's more likely just going to get canceled, and then they just turn you around. So they just take away the visa. So that's another way, fraud or misrepresentation. Also, I guess it's worth mentioning here, what happens if somebody's committing fraud or misrepresentation on someone else's behalf? So under the statute, to commit fraud or misrepresentation, you have to do it yourself. If somebody else does it for you, and you're, let's say, a child, and you're in no position to contradict what they're saying or to correct them, well, then they let you in, even though it was fraudulent, but it was fraud that somebody else did, so it will be used again. It can be used against that other person if they want to apply for a visa in the future, but not you. And you may need to document that with things like proof of your age, that you didn't know what was going on, Probably affidavits saying why it happened like that, etc. Now, of course, at the border, the immigration officer can also refuse entry to someone who has an issue with their criminal history. Okay. So they may already, because they're always gathering information now, and especially now with AI and with companies like Palantir who are helping them connect their databases and search them quickly and connecting a lot of the government databases together, essentially. It's easier for them now to be on the lookout for people who enter on a visa when they have a certain criminal offense. So, for example, a DUI, right, or a DWI or something like a drug or alcohol-related offense. If you're hit with that here in the United States on one of your visits and then you leave and then you want to try and come back, you may have that issue at the border where they say, hey, last time you were here, you got a DUI. We're not going to let you back in on your tourist visa because you might just get another DUI and put our people at risk. So no. So that's another reason. Those are called Prudential revocations, where the government maintains their list of all the people who were on a tourist visa and then committed a crime, and now there's a record. So they put it on a list. And again, somebody comes to the border on land or by air, when they're going through immigration, that's where the final check is done. And they'll say, actually, you have to go back home because of this. Now, sort of when we talked about fraud or misrepresentation, or the person has immigrant intent, one of the other reasons that Border Patrol or Customs and Immigration can stop somebody from entering, even when they have a visa, is when they say, there's an employment or some other status violation. So we talked about somebody working when they're on a tourist visa, but it may be somebody who has an employment visa that lets them enter and leave the United States. But upon questioning, it turns out this person had been fired, or the contract ended, or they no longer work at that company. And on many of these employment visas, they're not transferable. Right? You can't just say, oh, well, they fired me, so I got to go work somewhere else now. No, that visa's done. And when they fired you, you technically have to leave the country as per law. Another common scenario is somebody on a student visa, right? Someone on a student visa can enter and leave the country during their studies. But what happens if they flunk out? What happens if they drop out of school because they can't pay the tuition? What happens if the school kicks them out, right? They're no longer going to that school anymore. They no longer have proof of it. And, that's actually something the school is supposed to report to ICE and to Customs so that when people are entering and leaving, they can make sure that they don't get in on a visa that they're not supposed to. And, the common scenario there is, they'll give some brief questions about, their enrollment, how many days they go to class, what classes are they taking, what's the major, what's the name of the school. Or in the context of an H-1B worker, maybe they can't even name their employer, which is probably more common than you would think because, I've seen a lot of these H-1B visas and where they use some sort of H-1B contractor where it's like, Heart and Home Employer Services. But the person's actually placed with a landscaping company or, some sort of farm or a fishing operation or something like that. So that could be another reason, the employment instead. So what actually happens then when someone's denied? Well, they're left with a physical stamp on their visa that says canceled, right? So right on the page in their passport where the U.S. visa is, it's canceled. And then, immigration is going to cancel it in the system so that that person can't use it to enter later either. And usually it'll just say canceled. They may say canceled without prejudice, right? If they weren't totally convinced, but they think it was very suspicious, so they just denied entry. Maybe you can go reapply, maybe not. But typically, legally speaking, there's going to be two potential consequences. One, immigration may allow the person to withdraw their application for admission. This is the kindest and most generous route or thing that can happen for them. And the reason for that is every time you come to the border with your visa, you're saying, hey, I want to come in. I want to apply for admission to enter the United States. Here's my visa. And if they let you withdraw it, they'll say, hey, take it back. We think you're doing something wrong, so take it back. And if you do that, you sign that form, the form I-275. That's usually the preferred outcome. They can leave voluntarily. They're not formally removed or deported from the United States. Okay, it's that removal or deportation. They used to call it, legally speaking, it was called a deportation. Now it's called removal. Today, they're sort of synonymous, right? If you're removed from the country, the government's taking you and putting you back in outside the U.S. If you're deported, same deal. And there's legal consequences that go along with it. And so a withdrawal of your application for admission does not carry the 5-year bar. Okay, because if instead they remove you, the section of law that they're probably going to use is expedited removal, because an applicant for admission to the United States, someone who is at the border or a port of entry or an immigration port of entry at an airport, they're applying to enter the United States. That's the terminology we use. And then if they say, no, fraud, immigrant intent, you violated your status, we're canceling your visa, we are removing you from the United States. Well, now that person, they are the victim of expedited removal. Victim. Recipient, I guess. I mean, sometimes these things happen. But there's a formal removal order. Now, you don't go in front of a judge. You don't have a hearing. You don't have an attorney present. You don't get to argue your case. No, they found the evidence and they can take that action unilaterally for arriving aliens. If they couldn't, it would be a pretty tough system to manage, because you could have thousands of immigrants coming in on planes every day and saying, no, I want to fight it. But you can't fight it. It's expedited removal. That's the point of it. If you're just coming into the United States, we have the right to just take you out of the United States. Now, in a lot of the stuff that we've heard in the news recently, a lot of what we're seeing going on in Chicago, North Carolina, and a lot of other major cities where ICE is scooping people up, or where they've even scooped them up at an immigration interview, like where they're applying for residency. The government right now is miscategorizing people, and this is happening left and right. And the remedy is to go to federal court, file a habeas corpus petition, and resolve it that way. Okay, that's the only way to really resolve that situation right now. I have not seen that happen in Detroit. I don't know if it's a national aberration or if that's going to be happening everywhere, but it's not what we've seen in Detroit. But they'll misclassify everyone. Oh, you've been here for 10 years? Well, you're an applicant for admission because you're asking us to come in. So that's not right? It's the wrong section of law. And so that's one thing to be aware of, right? But if you're a recipient of expedited removal, you're going to have a bar for 5 years to apply for a visa again. Okay, it's not 10 years right away. The first time, it's 5 years, right? And it really can't happen a second time because they've taken your visa. They've canceled it already. Now, this is where a lot of people will get confused. And this is one of the questions I took not too long ago from someone online. And they were pretty adamant that, no, they didn't get deported. They were just sent back. Well, you don't know that, because most of the time it is an expedited removal. Like if you're looking statistically, it's an expedited removal. The government doesn't want to deal with this person later. They want to take them a 5-year timeout so they don't lie about the next visa that they apply for when they come in. And so you don't know until you look at the documentation. And most of the time, people don't have or keep this documentation. Immigration will say, hey, we are removing you. I want you to sign here to acknowledge it. And they'll be like, I don't want to sign it. Fine. We don't give a care if you sign it or not. You are getting removed. Here's your copy. And they might be like, I don't want to touch that paper. Like, fine. We don't care if you touch the paper or not. We can remove you on our own. So a lot of times the clients will not have this documentation, and you need to get it through a FOIA request. And that's what we'll do if there's any doubt about whether it was a removal or a withdrawal of application. Because if somebody gets expedited removal and then later they try and enter the United States without permission, well, now you're entering unlawfully after a removal, and now you have the 10-year permanent bar for which there's basically no waiver for, right? Rare exceptions for VAWA, potential exceptions if you have a U visa or a T visa application, but nothing else. The rule is you got to leave the country, wait 10 years, and then you can apply to come back. And so that's why it's so important to know what happens when somebody is refused entry at the border. If they were the recipient of an expedited removal and then they entered, well, there's a lot more severe consequences that attach. And instead, if they just know, okay, they go, they leave, they wait 5 years, and now they're applying for a visa, they haven't re-entered unlawfully, maybe we're okay, and maybe we can go forward. So once we request that FOIA and we get the response, hopefully we get the response. It can take a while. It might take a couple requests to track it down in the right place. There's a few techniques that we'll use in our office for it. We might send somebody to get their fingerprints taken, so we may take their fingerprints at the office because we have a scanner for that. We may need to get the FBI record or send the fingerprints to OBIM and do a fingerprint request there. But once we know more or less and we can submit that USCIS FOIA, and sometimes we can do that right away as well, just because of time. We want it to go as fast as possible for the client. Then we get the records and we have to analyze what were all of the grounds of inadmissibility that this person was charged with. Was it just immigrant intent? If it was that, it was also fraud. If it was fraud, what else was it? Is it because they were declared to be a public charge? Was it for some sort of crime that they have on their record as well? All these things we have to know if we want to help them apply for some other visa or get some other form of relief in the United States. Now, the complication for people who have been found to have committed fraud or misrepresentation is this. They need a waiver not just for a deportation. They don't just need a visa application that somebody can file for them, but they need to apply for a waiver of inadmissibility. Okay. And if they said, oh, you're a public charge, okay, fine, just show that you're not a public charge next time. But if you committed fraud or misrepresentation, now you need to file a waiver under Section 212I or 212D3 if you're applying for a non-immigrant visa. Now, this is not an easy thing to do because you need a qualifying relative. First of all, you need to show that you're sorry, you did it, and you won't do it again, and that you've got some good factors in favor of you being a guest here in the United States or coming to live in the United States. But you also have to show that you have a qualifying family member who's going to suffer hardship if you can't get this visa. And that qualifying family member is limited. Doesn't count for you to have a kid. You need to have a U.S. citizen or legal permanent resident spouse or parent in order to qualify for the 212I fraud waiver. And that's what tricks up most people. They may say, oh, well, I was denied at the border, but now it's been 5 years, so I'm applying. No, you need a waiver. And if you don't have a qualifying relative, you won't win the waiver. That's one of the requirements. You have to have it. So, what happens when you're stopped at the border and they don't let you in? That's one of the biggest problems. Now, if they've stopped you for a criminal reason, you may need to get a criminal waiver. Okay? Not as strict as the fraud waiver, but you still need to show that either you have rehabilitation or this thing is taken care of, or maybe, unfortunately, you committed a crime like trafficking in illicit substances for which there is no waiver, period. And even if you apply for a U visa or T visa, you already have to be in the U.S. But if you've got a drug trafficking conviction, they're not going to forgive that. Right? They may say, oh, it's possible. We'll look at the facts. They're not going to forgive it. They will not let drug traffickers obtain status in the United States. And so possession with intent to distribute, unfortunately, is a trafficking offense. So if somebody has that on their record, that's a problem. And there's so many crimes you can commit and so many potential immigration consequences. We can't list them all here. That would take probably a whole series of episodes. However, just knowing that there was a criminal reason that kept you from getting into the United States, you're going to need some sort of waiver for that. So in summary, if you're denied entry at the border, it doesn't mean it's the end of the world. It doesn't mean you can never get a visa. What it means is there's a little bit of work we have to do to find those answers. And that's going to take an attorney's work. This is not advice you can get from a notary or a form preparer. All of the statutes and all of the laws that permit limited form preparation are very limited in the authority it gives to a form preparer. They can't give legal advice. They can't counsel you on what makes you admissible or inadmissible. All they're allowed to legally do is handwrite or fill in an application with the information you provide. They're not even allowed to select the forms to use. Their role is strictly limited. For example, if you think of a community event where there's people who just need help because they don't know how to write, That's what they're there for. That's what they're allowed to do. But they can't choose the forms for you. They can't analyze your case. They're not going to know what a 212I or 212D, whatever, inadmissibility is, right? So, or 212A admissibilities, right? So they're not allowed to do it. They can't do it. They're no good at it. That's why you need an attorney. So if this has happened to you or somebody you know or somebody you love, and you want to know if there's a way that they can get a visa to the United States, give us a call. I do have a law firm. I am a practicing immigration attorney. Our law firm is Betzold Law, also known as visafeliz.com. That's visafeliz.com. And you can schedule a free case evaluation there. And then we can go on to a consultation if your case merits further attention. And for attorneys or immigration professionals out there, you need to be aware. Don't take your client's word for it because usually they don't know, right? They would know if they were given an expedited removal order. If they know, they know because they have a copy of it. But if they come in and they say, well, yeah, they sent me back. A lot of times the officers are speaking English to them. It's high stress. Maybe it was many years ago. You need to verify this information. Otherwise, you could be putting your client in a position where they go through a whole immigration process, go to the consulate, and then their case is denied. So let's do things in order, go through the right steps, find the right information, and we can help our clients do great work and get great results, right? Let's go over some common questions. Okay, so let's take some questions then. So the first question we have here is, they took my visa. Does this mean I'm banned from the U.S. forever? And the answer to that is absolutely not, but it does mean you're facing a legal question, right? It's something that could be complex. If they cancel your visa, that can sound scary. It can seem like, uh-oh, I just lost my chance at this forever. But that's not necessarily the case, right? So it's going to be important to know if they gave you a withdrawal of your application for admission, or if they gave you expedited removal. The legal consequences are different. If it was with withdrawal, you can generally avoid the multi-year wait or legal bar. And if it was an expedited removal, they're going to say right at the beginning, you have a 5-year ban. So during that 5 years, you'll need to file for a waiver. And so we need to see the paperwork on that, right? It's not just, oh, I think it was this. No, we don't want to walk down that immigration path, do thousands and thousands of dollars of work just to find out it was an expedited removal, and so you can't do this thing that we were hoping for you. So that's important to know. We have another question here. The officer went through my phone or laptop, and that's how they found the problem. Is that even legal? And the answer is yes. Yes, immigration can look at whatever they want of you if you're an applicant for admission to the United States. If you're coming to the border and saying, hey, let me in, they'll be like, fine, let me see what's on your phone. Let me see what's on your computer. And again, that's what they're looking for, is they'll look for anything to suggest that you're going to do something that's not allowed on the visa that you're using. So it could be evidence of unauthorized work, evidence of, and when we say unauthorized work, it could also be like unauthorized business dealings or things like that. If you have the B1, B2 combination visa, that lets you come into the United States for tourist reasons and for limited business activities, right? To attend a conference, to participate in a conference. Maybe you're giving a speech. Maybe you're just there to negotiate a contract and close a deal. But it doesn't mean you can stay there and work full time. So you got to be really aware of what you're telling immigration. What you want to be aware that what you're telling immigration is true, and that what you're planning on doing is lawful based on the visa that you have. And there's actually a whole list that you can find in the FAM, the Foreign Affairs Manual or Field Adjudicators Manual. This is a Foreign Affairs Manual actually with the Department of State, fam.state.gov, fam.state.gov. And you can find the whole list of approvable or approved activities when you're on a B1, B2 visa that you can do as opposed to the things you cannot do. Okay, so you've got to know. I can give you an example. I actually had an example from, this was a few months ago. I was talking to the client's mom. The potential client's mother came in and was like, hey, they took away my son's visa at the border. I don't know what we can do now. And so it turns out, we talked a little bit and they're like, well, I think we had the client on the phone as well, but they had gone through his phone and they saw that he was buying and selling all sorts of stuff on Facebook Marketplace. Now, that's not a permitted activity on a tourist visa. And then they found that he was friends on Facebook with someone who was posting pictures of them smoking marijuana together, and then he said, well, what were you guys doing here? Oh, well, we were making a music video. Well, isn't that marijuana smoke? Oh, no, that's fake. Well, it wasn't fake. It was real, for sure. And yeah, there was a music video going on. So you can't, I mean, that's employment. If you're making a music video for someone, you can't do that. And you can't be buying and selling stuff on Facebook Marketplace because that type of commerce is not allowed. And so it was a big deal. So yeah, they actually went through all of his stuff, found that he was violating his status here, and that he was probably consuming drugs here as well, even though he wasn't convicted of it. And they said, no, we're taking away your visa, and it's for fraud, and it's because of immigration intent, and because you violated your status. So he really touched on all these categories, including the criminal one. So that sort of individual is going to have more problems or more complications if they want to ever apply for a visa again, and they may be foreclosed from being able to even do that. Okay, so yes, they can go through your phone, they can go through your laptop, and they can find stuff. And if they do, that could mean cancellation of your visa. Let's go to the next question. I had a DUI, so a drunk driving, from 5 years ago. I thought it was fine because I got my visa renewed last year. Why did they cancel it now? Okay, this is another example of what we talked about earlier with Prudential revocation. It was prudent for them to revoke it. So it can be a surprise for many people when they show up at the border. So even a DUI can trigger an automatic system-wide visa revocation by the Department of State. You might not get a notification about this. So it'll be invalid electronically. And again, you're going to discover that when you're going through immigration, trying to come into the United States. Again, maybe they let you withdraw your application for admission, or maybe they give you an expedited removal. So any sort of criminal activity that can require visa cancellation may also require a waiver of inadmissibility when you want to turn around and apply in the future. With the U.S. immigration system, convictions on your record don't just expire. It's there. It's there forever. And I know some countries will say, well, in the last 5 years, if you've had one of these things, then you can't come in. Well, not with the U.S. If you've ever had, possession of marijuana, you're going to need a waiver. If you've ever had possession with intent to distribute any other substance, well, you're going to need a waiver, and you probably will not win it. In fact, you won't win it because you're precluded from even applying for that. So criminal activity can be a reason for that prudential revocation and can be a surprise. Here's another one. I just came to help my sister with her newborn baby. The officer said I was trying to live here and canceled my B2 visa. What did I do wrong? Okay. Hopefully you're paying attention at the time, because they're probably going to say more than just, oh, we're revoking your visa. The questions that they ask are going to be the key to figuring out why they're denying or canceling your visa. Okay. So this could be under 214B, where there's just the failure to overcome the presumption against immigrant intent. So this person did not convince the officer that they were just going to be here temporarily, right? Your B2 visa lets you into the United States for up to 6 months at a time, or some other time limited by what immigration puts into the system or on your passport when they let you in. They can say, yeah, you can be here for up to 6 months, but we're going to actually limit you to 2 months. So that can happen. And if you're saying, well, I plan on being here until the child's a couple of years old, just, to help out my sister. Well, that's more than the 2 months. That's more than 6 months. And that's way longer than you're allowed. So if they think that's your plan, that can be a reason that they don't let you in at all. They may think you have insufficient ties to your home country, right? So if they're asking, all right, where do you live? Oh, I live in, I live in this city in Mexico, and, I sold my house and I sold my car and my bike so I could take this trip. And they're like, wait, you sold your house? So you don't have a house to go back to? You don't have a car waiting for you back there again? No, we think you're moving here, so we're going to deny your entry. So that's another reason. if you're carrying documents like a job application or a resume or a lease, things like that, that can all be evidence that you intend to actually immigrate. If you spent too much time here recently, that could be another one. Or if you gave inconsistent answers, right? If you say, oh, I'm coming in to help my sister with her baby. Okay, well, what do you do to support yourself while you're here? Oh, well, she pays for me. She pays for all your stuff that you do. Looks like you spend a lot of money on alcohol based on your Facebook posts. Oh, well, I do like odd jobs to help other people. Oh, you do odd jobs. You see, that's not allowed. So those answers can lead them to denying you based on this scenario as well. So that's an important one. Let's see. We got another question here. I was just canceled and sent home. Can I buy a ticket and try again tomorrow at a different airport? No, absolutely not. That would be a major mistake because the moment your visa was canceled and you were sent back, your name and the entire file of the incident went into the Central Immigration Database with CBP, Department of State, USCIS. If you show up again tomorrow, the next officer will see the record and they're just going to send you back, and they will definitely remove you expeditiously, right? You'll get expedited removal. You'll have a 5-year bar. The next step for this person would be to not travel to the United States, but instead look at what waivers are necessary, or if they have some other visa they can apply for. And again, if they don't have any of the documentation from this, it's a Freedom of Information Act request waiting, and you want to send those to various agencies and probably a fingerprint request as well. Any travel done before then, especially if it's undocumented, will just lead to a lot of immigration complications in the future there, okay? So travel will be out of the question for the moment for that individual. So we have another question here. The officer made me sign a paper but wouldn't let me read it or call my lawyer. What exactly did I sign, and can we undo it? Okay, this is where the situations can be complicated, right? Because if you don't know what you signed, well, how are we supposed to know? But there's only a few things you would be signing. One, it could be the withdrawal of application for admission, right? The officer's supposed to inform you of your rights, but you don't actually have the right to an attorney in this expedited removal process, or if they're telling you need to withdraw your application for admission. Okay. So a lot of people do report feeling pressured to sign it, and so they do it. Well, a lot of times they really don't have any other opportunity or any other option, because if you refuse to sign the I-275, if you don't withdraw your application for admission, they really don't care. They could just say, fine, well, then we'll just remove you with expedited removal. Okay. So it's better to have the withdrawal of application for admission for technical and other reasons if you want to reapply for a visa. But if that's not what you're doing, then you could get expedited removal. This brings up another good question about people who are residents of the United States, right? Green card holders, legal permanent residents. If they're outside of the country for more than a year, and then they try to come in without applying for a returning resident visa, that's a SB1 visa. If they're coming back in after an absence of a year, immigration is going to be very suspicious of them, and they may pressure them to sign to sign the form to abandon their residency in the United States. You don't want to sign that. Never sign that. And that form that we're talking about there is the I-407. So sometimes we'll see residents of the United States, for some reason, usually beyond their control, they left the United States, were gone for more than a year. When they come back, the government will say, hey, we're automatically assuming that you're abandoning your residency. Even if they didn't really abandon their residency. They didn't intend to abandon it, but they were gone for more than a year. Okay? Never sign the I-407 in that circumstance, because you're entitled to have a judge look at the situation. The judge can review your case and say, well, let's see if they actually intended to abandon their residency. Did they have a house here? Did they sell it? Did they have other stuff here? Did they sell it? Were they buying stuff in their home country? Like, what did they tell their family, their friends? Was there a medical situation or some other emergency that came up that prevented them from coming back here? And you can have a judge review it. So it's not automatic that you lose your residency just for being gone for more than a year. But it does mean that you're going to have to go in front of a judge and discuss that and prove that you didn't abandon your residency, that can happen. But if you sign the I-407, if you sign that and abandon your residency, it immediately ends your residency status. Your green card status is done. You have to surrender the green card, and it can also trigger significant tax consequences as well. So if you want to get your residency back, you have to start that whole process over again. So this is something completely different. This is for green card holders only when they've been gone from the country for more than a year. And immigration say, well, you got to just sign this because you abandoned your residency. That's not true. You don't have to sign it. In fact, the only time a resident would sign this form, the I-407, is if they've already made the permanent decision to live abroad. Okay, and if you need immediate proof of abandoning that in order to apply for a tourist visa or some other temporary visa to come and visit the United States, right? That's pretty rare. So it's good general advice to just never sign the I-407. You do not want to abandon your residency voluntarily. Okay, so I hope we shared a lot of good information here today. There should be a lot that you've learned, and we hope it's been useful. I am attorney James Betzold, a practicing immigration attorney, also the founder and CEO of Prima.Law, which is immigration practice management software. So if you're an immigration professional, go check out www.Prima.Law. There's a 15-day free trial. The software is amazing. If you're someone who's been stopped at the border, or you have a loved one who was stopped at the border and something like this happened, you can feel free to reach out to us at www.visafeliz.com. That's visafeliz.com. And, we can do an evaluation. We'll check out your case, and we can start doing the hard work of investigating what exactly happened, what are the legal consequences, and make a plan for you to apply for that visa or that green card status. Again, I'm attorney James Betzold. Thanks for joining us today. If you enjoyed the show, please take just a moment and like and subscribe. You'll get notified when new episodes are released. Now, as always, we're sponsored by Prima.Law. That's immigration case management. We are a legal case management platform specially designed with additional features for immigration attorneys, so we can really bring out the best in immigration attorneys, helping them serve their clients better by accepting online payments, using the client portal, sharing that checklist directly so your clients can share those secure documents in a very secure manner. Find a free 15-day trial at Prima.Law. That's for immigration attorneys and immigration professionals. Let's start the show.